Steve and I are both law partners at a very small firm in downtown DC. Steve is a litigator, which means that if you are actually suing somebody, you know, Steve is somebody you would hire or would be on the other side. If you're lucky, he'd be on your side. I tend to do, as my dad said, do technology stuff. I spend most of my time helping out DirecTV. So if you need to get a satellite dish on your roof, I can do that for you. The deal is this. If you are setting up your own company with just you, and you're doing something very, very simple, and you don't have any questions to ask, you can go ahead. It's generally cheaper and better for you to use an internet company. If you are working in partnership with somebody else, or if you have questions to answer, then it's useful to consult somebody. And so that's where you can save some money. But let me step back for a second, and this is something that's important. Why do you set up a company? If you want to run a food truck, why do you set up a company to have a food truck? Why don't you just buy a food truck and run it? And the reason has to do with liability. What the company does, so if you have a company through which you own your food truck, and something goes wrong with that food truck, boiling oil pours on somebody, or the food truck runs into another car and causes an injury, okay? Somebody's going to want to sue you. What the company does is it forces them to sue the company and not you, which means that they can't go after your assets personally. So the entire reason to have a company is to protect yourself from being sued when something goes wrong. And that goes for any company that you have. So I guess the first lesson ought to be that if you're going to do something business-wise, you need to have a corporation, whether it's an S corporation, LLC, or whatever. That's less important than that you have a corporation. Because otherwise, if something goes wrong, they can sue you personally. And that's the entire point of having a company. Now, the other sort of key, again, much more important than the type of company that you choose, is that you actually act as if the company really exists. And what I mean by that is that you don't mix your money with the company's money. You have a company bank account, and you have company forms, and you act as the company and not yourself. And so you're not using your own personal assets. You're not commingling is the term that the lawyers use. Because what will happen, again, if you guys pour boiling oil on somebody, that person goes to sue you, he will want to sue you. Why? Because you probably have assets, and that'll make you want to settle. So he will go before the court and try and argue, look, he's got a company, right? But it's a sham company. He's not actually, it's really him. And you'll have a whole fight at the court as to whether the company is real or not. And the key to keeping your own assets safe is to actually take the corporate form seriously. Again, don't mix money. Don't act. Mixing money is sort of the biggest one. Mixing bank accounts and things like that. When do you need a lawyer when you're setting up a company? Again, if you're doing something complicated, if you're doing something with other people. Often, the sort of typical thing is well, my brother-in-law wants to set up a company with me, and we'll talk a little bit more about that when we talk about the benefits issues. But my brother-in-law wants to set up a company, a construction company. Okay. At that point, just those words alone tell me that you probably want a lawyer. Why? Well, when you set up the company, you're going to want an operating agreement. You're going to want to know, for example, what happens if your brother-in-law is no longer your brother-in-law. All right. If you try and set something up on LegalZoom by yourself, that document probably won't answer that question, right? Let's say you've got 3 people, right? You want to know who's going to be in charge of making decisions, right? And it may seem like something that you don't have to figure out beforehand, but you don't want to figure these things out when there's a problem, right? You want to have a document that says, okay, X and such is going to make a decision, or it's going to be a majority vote, or whatever it is. These basic things. These are the things that lawyers can help you sort of figure out before you get it.
How do you find a good lawyer?
All kidding aside, my firm is very small. We do a few things, and we tend to be on the pricey side. But what we certainly can do is if we can't do something or if it doesn't make sense, we can find you somebody who can. So if you guys take one thing away from this, it should be call Mike Nilsson and I'll find you somebody. Or I'll find you somebody who will find you somebody. Litigation is very difficult. It's generally expensive. is in almost all cases a last resort. So if you've got a lawyer who is very eager for you to litigate, that's a red flag.
You want a lawyer who's going to be honest with you up front and say, look, here's the strength of your case, but here are the weaknesses. And we tend to kind of emphasize the weaknesses so that people can go into situations with their eyes wide open. Important to remember is, as the client, you have the right to fire your lawyer at any time.
The whole point of having a contract is to have the meeting of the minds between two sides, figure out what's going on. So the most important thing that a lawyer can do is help you figure out what's in the contract so that you know what's going on, and then can help you, again, anticipate disputes. What happens if the partnership winds up? What happens if this happens? What happens if somebody's unhappy? How does it get resolved? Contracts are no substitute for trusting the other side, and my dad will talk about this a lot. It's 100% true. A contract won't protect you from a bad business relationship, and in fact, sometimes it'll give you a false sense of security. You want a good business relationship, and you want to resolve and anticipate disputes before you even get to the contract. You want a partnership that works together, ideally. But one thing that is important with the contract is termination, right? One of the things that I always try to insist on in my contract is the ability for either side to walk at either time. That way, if anybody's unhappy, you just wash your hands of the deal and nobody gets hurt. That sets the incentive for things to work out. Right?
You want to make sure that when you're negotiating a contract that you're actually participating in the negotiation of the contract. If someone just hands you a contract and says, here you go, sign this, without any input from you, don't sign it. Or make absolutely sure that it's what you want. Because as part of the contract, you should be intimately involved in negotiating the terms of that. I get involved when that relationship has completely broken down, where both parties sort of have lawyered up and are ready for battle. So a lawyer in that situation is your advocate. You want somebody who's going to argue for you, present your position, but the lawyer is also a counselor. You need someone who will give you honest advice about your chances. Sometimes it does not make sense to litigate. And this is especially true I expect to be true for you all if you start your company. You start a company, it is your baby. You pour your heart and soul and all your energy into this. You pour your money into this. And so the last thing you want to do is sort of capitulate, surrender, and have this business you've tried to start go bad. But you've got to look past the emotion, and you got to make a dollars and cents decision about what makes sense and what doesn't make sense. Be very careful what you say, but especially what you put into writing. Start protecting yourselves from the get-go, even if it hasn't fully blown into people lawyering up. But if you see kind of a conflict dispute on the horizon, that's a good point to go talk to a lawyer and maybe head it off before it turns bad. But certainly don't fire off that FU email at 1 o'clock in the morning, because I guarantee you will see that again in court. I'll write an email to them right after and say, hey, just confirming our conversation, this is what we agreed to, 1, 2, 3, which is especially helpful when the other side is not particularly honest. But as you're in your business, if you have oral agreements, it's always good to try to memorialize those, even if not in a formal contract, but just in your own notes, in an email to their side. All of this will help if you end up in litigation to allow it to go smoother.